Article 49 is so clear that when a person has been brought to court, he'll be released on bail. Does not say anything else, because if the legislature had an intention, they would have said attempted murder cannot be bailable. That is not in the Constitution. It is not anywhere. So they cannot come here and categorize it by themselves when we are following the law. Not today, not ever. So under Article 49H, we are here in court today. So are they opposing because somebody is in hospital? That cannot be a compelling reason, Your Honor. That cannot be a compelling reason. And if their health takes a turn to the worse, and that can only be death, then the charges can be changed to murder. And we shall come back here and we shall apply, and they can oppose if they so wish. But at this particular moment, no way. But you're being told they also intend to apply for witness protection. But what does the prosecutor tell you? That the accused person was so brazen that he could shoot 3 officers, and 3 people, 2 of them being officers when they were armed. The accused person has denied those charges, hasn't he? If they can say that, then we are also saying, and which we had said before, that the officers are the ones who attacked him and provoked him. So if they want to bring that evidence that is not supported by anything else, what are we supposed to do? Your Honor, that is why you come and protect us. If these officers are armed, as the prosecutor says, and the accused person is armed, what does he do with his weapon? And you're being told it's unprovoked. And you're being told it was unprovoked. How did the accused person know that these are police officers and they were armed? How did he know if they did not show their weapons? If they did not threaten them with him with those weapons? And that is our story. So you'd wait and be shot? Every case shall teach us in its hour. So when the case comes to court, let that evidence come in. That cannot be used for the purpose of denying bail and think that you are so brave as to shoot police officers. How is that a compelling reason? So what have they done? The weapon that they are saying that he used is the weapon that he have taken for ballistics and will be an exhibit in this case. So they must tell the court, does he have another weapon? Have they proved that? Have they shown that? That would have been a compelling reason. Not an offense that he has denied. And you're being told now the witness protection program shall start. Yes, that is okay if they are apprehensive, if they are fearing. It is an option that is for them. But that does not make it a right for them to say that the accused person be denied bail. That is why the witness protection program is there. But they're telling you again, most probably he will interfere with witnesses. 2 of the witnesses are police officers. 1 is the waitress. You have not been told about any other witness or been given a name. Will he interfere with policemen? That is the question. Can he be able to interfere with them? Can he be able to intimidate them? If there are any other witnesses that are afraid, today you would have those names in the affidavit, and you have none. Not even of the police officers, except 1. But does it just end there because it's in the affidavit? No. In the case of Richard Alden versus Republic, that is case number 48, of 2016. Before your sister Justice Lastit.
Do you have a copy?
No, I'll give it. I've sent somebody to make photocopy. Case number 48 of 2016. Richard David Alden versus the Republic. This was before Justice Lastit. What did the court hold about such fears of interfering with witnesses? For the prosecution to say that they must show that the accused person has actually tried to interfere with the witnesses or attempted to do so, or has actually done so. That is what it is. It has never changed, and nothing has ever overruled that. Justice Korir, in High Court case number 61 of 2012, Dwight Sagarai and others versus the Republic. Yes, that is case number 61 of 2012. That was before Justice Korir. He also held the same position that something must be put on the table to show that he has interfered with witnesses. And he was a diplomat, Dwight Sagarai. Why was the court saying that material must be put before court? It's because this kind of allegations, the sky is the limit. Anybody can come and say that, and you are denied bond. How do you cure that? They must produce evidence. They must show you something. So today, have they shown you anything, Your Honor? They have not. So they want you to imagine that that can be true. They want you to go by probabilities. They want you to just assume that what they're saying is gospel truth. This is a court of law. It must go by facts. For them to say that he is going to abscond, even in those two authorities, again, the High Court has held that they must show that he has attempted to do so, or prepared for a journey, or has bought some tickets, or made some traveling arrangements. Those are the keywords in those authorities. They have never been changed. They have never been challenged. Have they shown you that about his absconding? Again, if they were to say that, the sky becomes the limit. So these rights are there so that they protect the accused person, because that from the moment that he has become a suspect or he's been arrested, he becomes a favorite child of the court. And these bills of rights are activated so as to protect them. And that is why Article 20 and Article 21 say that they must be exercised in a way as to favor the person asking for those rights, not to start by wanting to prevent. So what have they done today? What have they done actually from day one? They have raised an issue after an issue after an issue. And so this activates for us Article 22, whereby when we know that our rights are being curtailed, then we have a right to come before court. And this is what we are doing right now. So under Article 22, we are coming and saying, we have noticed from these affidavits, they are intending to make sure that we stay in custody. So once we have come to you under Article 22, what does the court do? The court then activates Article 23, which is read together with Article 165 of the Constitution. And therefore, when it does that, it starts by wanting to grant us our rights. So then, if that is the position, have they then given you any other reason that is compelling? Counsel for the Victim Consent tells you there is a bill. It tells you it is about 4 million shillings. tells you that me and him are good friends, which is true. He also tells you that we had discussed this matter, which is true. He tells you the mother had gone to visit the victims in hospital, which is true. For us to have allowed him to have access to us and talk shows what, Your Honor? Does it show a bad person? It shows you good faith. And good faith goes a mile. But if we were to start even an alternative dispute resolution, if we were to do anything else, how are we going to do it when the accused person is in custody? How does it happen? How do we negotiate? It cannot then be possible because right now it is the mother and she's somewhere here seated, an elderly lady. She's the one who's here. She's been going. But you're being told, because the deal is about 4 million shillings, deny him bail. You know, how is that related with his fundamental rights? We know, yes, the victims are suffering. They're being told they're economically and financially damaged. Those are the words. Physically damaged. Still, Your Honor, how does that prevent the rights of the accused person coming out on bail? Because nothing is changing at the moment. The bill will go up, yes. Physically challenged, but physically damaged for that moment does not change. That cannot be a comparative reason. But then again, as we go by, we are being told that he ran away. He disappeared. He disappeared from police officers who had guns. Until counsel brought him to the police station. Yes, we did that. Physically took him to CID headquarters, presented him in front of the investigating officer. They took his statement, and he was charged. But look at it this way, Your Honor. This person who's supposed to be absconding, who had the opportunity, had the time, and probably the means, did what? Went to a lawyer, got comfortable with the lawyer, and came. Again, what does that show you, Your Honor? It only shows you good faith. He wouldn't have come. If he wanted to abscond, he would have gone. People are in hospital, and he knows it. It was all over the news. But he came. So you're being told, look at those antecedents. What antecedents? What about when he came back? Isn't that a good antecedent? Isn't it a positive one? He surrendered his weapon. Isn't that a good reason? Isn't that why, Your Honor, you should treat him fairly? Treat him as your favorite child today because he has done all this. Isn't that good? Are they ignoring or forgetting that that happened? Justice Lesit and Justice Correa, again, those two authorities are like twins. Say that keeping an accused person in custody because he's going to abscond can be cured by giving stringent terms. I like the fact that the prosecutor said that in case you do so, give stringent terms and let him deposit his passport. He is saying passport can be deposited. Terms of bail must be given, not because they have to be strict, just to ensure that the accused person appears in court. That is the first reason of giving bond. That is the first reason. The others are imaginary for the time being. So what else can you do? Can you be giving him reporting orders? Yes, you can do that. Can the orders be made that he reports to court or to the investigating officer? The court can do that. But what does Article 49 say? The terms and conditions must be reasonable. Must be reasonable. Reasonable does not mean strict. Reasonable does not mean tough. Reasonable only means that they can be able to be met by the accused person so that he can appear in court. That is what reasonable is. Because today, Your Honor, if you give him terms that he cannot meet, what does that mean? It means that it's like he has been denied bail. Counsel says it is going to be a civil case. Most likely, most probably. If there's going to be a civil case, why don't you wait for civil court? Why are we bringing that story here? If it comes as a civil matter, it shall be handled. It shall be taken care of. That's in a different forum, in a different arena. As you were saying, there is a case of the land case whereby some of the victims have not appeared in court. Maybe they passed away, or witnesses passed away, or murder. I have so many cases that I can be able to quote, even if I start with the Obato case, the Babu Owino case, the Ken Muyundo case of recently in Kitale. All these people are out on bond. What has happened to the victims? Nothing. Treat each case with its circumstances, because each case is unique like a fingerprint.